Berardi Immigration Law is a great resource for the latest in immigration news and trends. Please be sure to subscribe to our channel. It really helps out the channel. And click that notification bell so you never miss a video from Berardi Immigration Law.
Hi, my name is Zach Ahlstrom and I'm an attorney at Berardi Immigration Law. In this video, I'm going to discuss the E-2 investor visa, including how to qualify and the application process. Now, the E-2 visa is a temporary U.S. work permit available to foreign investors. To qualify, an applicant must first demonstrate that he or she is a national of a treaty country. There are currently over 80 eligible countries, and a list of the qualifying treaty countries can be found on the U.S. Department of State website. Now, next, an applicant must prove that he or she has invested or is actively investing a substantial amount of capital in a bona fide U.S. enterprise. It is important to note here that there is no set dollar amount that constitutes a substantial investment for E-2 purposes. Rather, officers look to see if the investment is proportional to the type of business. Reviewing officers want to see that the investment is of a magnitude that will support the likelihood that the business will succeed and also that the investor will continue their financial commitment to the company. In addition, investment funds must be at risk and irrevocably committed, which means it's not enough to simply transfer funds to a U.S. bank account or invest in idle property. A qualifying investment must not be idle nor speculative. A couple of other important notes here are that E-2 applicants must invest in a bona fide, non-marginal U.S. business. The bona fide element of this requirement means that the U.S. company must be real and active commercial or entrepreneurial undertaking that will produce goods or services for profit. In addition, a non-marginal business means that the company must have the future capacity to generate significant income and create jobs for U.S. workers. Now, the last major E-2 visa requirement is that the applicant must be seeking entry to the United States solely to develop and direct the enterprise. This is established by showing at least 50% ownership of the enterprise or possession of operational control through a managerial position or other corporate device. Now that we've discussed the E-2 requirements, let's chat about the actual application process. The first step in applying for an E-2 visa is determining where the applicant will apply. This is important because each U.S. embassy or consulate around the world has their own specific submission requirements. For the most part, however, the application process involves two steps. First, a copy of the E-2 application is submitted to the embassy for review. Once the application has been reviewed, the applicant will attend an in-person interview at the embassy or consulate. Following a successful interview, applicants will then receive an E-2 visa in their passports, which is typically valid for multiple entries over several years. The actual validity period of the visa will depend on the applicant's nationality. For example, in Canada, E-2 applicants are issued a 5-year visa, but in Australia, E-2 visas are only issued for a maximum period of 4 years. So if you're interested in applying for an E-2 visa or just have questions about the application requirements or process, please do not hesitate to contact our office. Thank you.
Thanks for watching. Be sure to like our video, subscribe to our YouTube channel, and hit that notification button so you never miss one of these important updates. Also, check out the Berardi blog that's on our website at berardiimmigrationlaw.com. The blog is updated 2 to 3 times a week, contains tons of up-to-date information on policies and trends. You won't want to miss it.